Morning, members. The meeting of the Subcommittee on Fugitive Offenders, Czech Republic Order, Mutual Legal Assistance in Criminal Matters, Spain Order, and Mutual Legal Assistance in Criminal Matters, Czech Republic Order will start now. Can we first elect the chairman? Well, I'm nominating you, Mr. James Toe. Would you second that nomination? Yes, because if you don't, then of course we can proceed. Okay, then I declare myself elected then. Thank you. Do we need a deputy chairman? No, I don't suppose so. Can we invite the administration in, please? Now, there are 3 orders under consideration. The Secretary would like to remind us for the Fugitive Offenders Czech Republic Order. It's by negative vetting, so there is a time limit involved. So in any case, maybe we should first deal with this negative vetting order before we go to the mutual legal assistance order, because the 2 MLA orders are by positive vetting, and we should have more time to consider them. Okay, no objection. Now, first of all, can I welcome the administration representatives to the meeting. We have Mr. Vic Yao, Principal Assistant Secretary for Security, Mr. Hagen Li Tang, Assistant Secretary for Security, and Miss Elizabeth Liu, Senior Government Counsel, Department of Justice, and Miss Carmen Chu, Senior Government Counsel, Department of Justice, and Miss Angie Lee and Miss Phyllis Poon, both are also from the Department of Justice. Welcome. Now, first, let us deal with the Fugitive Orders Czech Republic Order, the Czech Order. I'll now hand over the floor to Mr. Yao. Now, in the past, we would always look at one angle when considering these orders. That is, because we have standard text, and so we would like to compare that with our with the standard text to see whether there are any differences. That is the model agreement, and of course our attention would be on the departures from the model agreement. Thank you. Let me first brief you on not just the Fugitive Offenders Order and also the 2 Mutual Legal Assistance Orders, and then I'll see if members have any general questions, and then I will invite Ms. Liu to go through the clause-by-clause comparison with the model agreement as suggested by the chairman. Now, with the authorization of the Central People's Government, we could make certain agreements with other countries. There are 2 types, mutual legal assistance in criminal matters and surrender fugitive offenders. And after the reunification, Hong Kong has been actively reaching agreements with other countries on these matters to help combat crime. Now, MLA orders or agreements are about providing assistance to other jurisdictions, for example, taking evidence, seizure and surrender of persons and criminal proceeds. Now, as for the Fugitive Offenders Order, is about the surrender of arrested persons to other jurisdictions. Now, we have now signed a number of MLA orders and Fugitive Offender Orders. The latest agreements are the Spain and the Czech Republic orders on MLA, and also the Czech Fugitive Offenders Order. Now, in accordance with the relevant legislation, these there's a need to enact subsidiary legislation under the Fugitive Offenders Ordinance and the Mutual Legal Assistance in Criminal Matters Ordinance to give effect to these agreements signed with Spain and Czech Republic. And as the chairman mentioned, we've already submitted a clause comparison with the model agreements. Well, in the course of negotiation with these jurisdictions, perhaps in the light of the requirements or the differences in their legal systems, so sometimes there is need to depart from the model agreement. Well, even if there are such departures, the agreement signed would not exceed the scope of the Mutual Legal Assistance in Criminal Matters Ordinance and the Fugitive Offenders Ordinance. That's all by way of a brief introduction. If I wonder if members have questions. If not, then we'll go to the clause-by-clause comparison. Yes, please continue, Ms. Liu. Thank you. Good morning, Mr. Chairman, members. First, I will talk about the Fugitive Offenders Czech Republic Order. First of all, in terms of the preamble and the title, where there is a difference, is that we've taken out the reference to government. Now, under the... please, hold on. Mr. Chairman, members, we're now referring to Annex B to paper number CB bracket 2339 stroke 13 to 14 bracket 03. This is about the article by article comparison with the model agreement. Now, the first difference with the model agreement is that for the title and preamble, we have taken out the references to government of, because under the Czech legislation, such agreements require parliamentary approval and signature by the President. So to the Czech Republic, the agreement should be with the Czech Republic, not the government of the Czech Republic. So it's an agreement signed between the Czech Republic and the government of the Hong Kong SAR. That's why we have taken out the references to government of. And also, in the Czech legislation, there is no definition for fugitive offender. So in response to their requests, we have changed the wordings from fugitive offender to persons wanted for criminal proceedings. So that's the difference in the title. Article 1, obligation to surrender. The text is substantially the same as the model agreement. But again, in response to the Czech Republic's request, we've made some amendments to the wordings, but the meaning is the same. Article 2, central authorities. We have regard to the actual situation involving the two places, so we have given a definition to central authorities. It's not in the model agreement, but it's for the for facilitating the actual operation of the agreements. Article 3, offences. There's a departure from the model text. We have not adopted the list approach this time round. We've adopted a different approach. Under the Czech legislation, like many other jurisdictions that practiced continental law, for all offences, the fugitives could be surrendered, but in Hong Kong we have a list approach. But this does not apply to the Czech Republic. That's why this time around we have adopted a new approach. So in the agreement we have not included a list, but before the commencement of the agreement we will have mutual exchange of lists. Now, for past fugitive offender orders, we've always adopted the list approach, but for this order it's not the case. Are you saying that when we sign agreements with other jurisdictions there won't be a list? Well, there will be two options. For some countries, they're familiar with the list approach and they find it acceptable. like many common law jurisdictions, they would they would prefer the list approach. So we will keep to the list approach. So there are two options in negotiating agreements with other countries. So it depends on the country involved. We'll see which approach better suits their circumstances. Well, but you say for the Czech Republic, there won't be a list approach. I don't quite follow here. But then according to the ordinance, you have to exchange a list of offences. So it's not a question of whether there is a list or not, but rather whether you include the list in the agreement. Because in our ordinance there is a list. Yes, so it will lead to a number of issues, because it says here in future there will be exchange of list of offences. So that means we do not know what offences we recognize mutually, but rather is writing a blank check or giving a carte blanche. It's like you don't fill in the amount in the check and you give it over, hand it over. You say we may agree on those offences between the two negotiating parties, but then the legislature may not agree. Then there's no way we could deal with that. So would you be undermining the authority of the legislature to monitor such issues? And for a member of the public, say there's a fugitive from the Czech Republic in Hong Kong, and you could arrest a person with an arrest order, and then he finds a lawyer, whether it's the member of the public or the lawyer, would say, well, there's a particular offence that the person's committed in the Czech Republic, but is that an offence that's extraditable? We wouldn't know. So what we do, we write to the administration. What is the list, the exchange list? What's on it? And then you say, oh, it's on the list. Out of the blue. So that means no one would know if a person has committed an offence in the Czech Republic, he comes to Hong Kong, we wouldn't know which offence is extraditable. And the person could be extradited to the Czech Republic. So there's no certainty of the law. How come you can do that? Can you please explain it? Let me try to explain, and Ms. Liu could supplement if necessary. Mr. Chairman expressed concern about the unclear scope of extraditable offences, and we wouldn't know what such offences are. But actually, if you refer to the text of the agreement, that could address the concern. Article 3 of the agreement, it says that for the contracting parties, they would both allow, that is only for offences under the relevant legislation of the two jurisdictions which are considered extraditable before the fugitive could be surrendered. So in Schedule 1 we have listed out the offences which are extraditable. So for members of the public or lawyers, if they see that if it's an offence, extraditable offences are permitted under the laws of the two jurisdictions, then it's fine. No, Mr. Yao, you don't quite follow what I'm saying. What you're saying is that at most the 46 offences we permit under our laws, but perhaps there are just 23 offences. The 24th offence is not there. Then I wouldn't know. You mean Schedule 1? No, the mechanism is that you don't include offences in the order. In other words, when we refer to the order, we would answer which offences are extraditable with the Czech Republic. It could be from 0 to 46. Oh, no, not 0, perhaps 1 to 46. Offences number 1 to 46. But which is on the list and which is not? We wouldn't know. So there's no certainty of the law. What is the certainty? Is that, okay, at most there are 46 offences, but then it's possible that 46th is not on the list, that 45th is not on the list, and whatever. We wouldn't know. Why is it like that? It's odd. And then DOJ colleague says because the other party doesn't want a list, but I don't understand at the end because there will still be an exchange of lists, so there's still the list approach. So how can you say that they don't like a list? Now, at the title, they say that they like to use the People's Republic. They just want to say the Czech Republic, so not the government. So the agreement signed between the Czech Republic and our government, not with the government of the Czech Republic, that we can follow. Because that's their custom to sign agreement as a country, not as the government of the country. Perhaps in the constitutional system, the legislature or the executive are all considered as representatives of the people. Well, that we can follow. And there's still certainty there, because it's clear it's not the government. But now here, without list, we cannot be sure. From offences number 1 to 46, we wouldn't know which one are on the list.
Allow me to respond, Chairman, once again. Of course, this is the first time the Czech this is the first time we have not adopted a list approach in our FO agreement. When we exchanged a list of offences with the Czech Republic, Hong Kong will inform our counterparty the offences number 1 to 46. What about the other way round? Yes, the Czech Republic would also tell us laws, offences permitted. Please supplement. Well, the Czech Republic allow all the surrender of fugitive offenders who have committed crimes punishable by over 6 months of imprisonment. So we believe the offences, the list of offences would include all the offences permissible in Hong Kong. Well, the Czech Republic allows surrender of fugitive offenders for all sorts of offences. So in negotiation with these companies, very often they tell us that they don't have a list. So all kinds of offences apply. However, in our law, we do have a list. And therefore, there must be an exchange of lists. I get that. But you can say in the agreement that for us, this is our list. And for them, it is all offences permissible in their law. So you just add it into our schedule and you list out all 46 offences. Now, there is some uncertainty here. Assuming that we have 46 offences and they have thousands or indefinite number of offences. Now, if the intersection or the overlapping area is very limited, so how do we deal with offences that are not common to both parties? You mean offences that are not punishable in Hong Kong. So at the end of the day, it's only 46 offences from Hong Kong. Yes, you look for the common set. Now, we talk about the offences common to both Hong Kong and the Czech Republic. So we talk about the common set. So why don't we list out the common set of offences? Because this exchange of list offences, we have only got 46 offences, for instance. All right, they have a set of offences and we have a subset of offences. Now, I understand that the other party doesn't want to include a list. But for us, we can tell them that this is our list. Well, if you don't want the list, it's okay. Can that be put in the agreement? It's not that they don't want to include the list, because according to the paper, they will exchange a list of offences. Yes, we were thinking that we might think that we have a list of offences, but perhaps the list is offences that are regarded to be so in our country. Well, theoretically, this is not going to work, because some of the offences will not be applicable. the agreement only applies to the common set of offences of the two states or the two parties, because in Hong Kong we've only got 46 and won't go beyond that. Mr. Yao, of course the list of offences is important, but we have to look at the law itself. Or what does it say? Permit for which surrender is permitted by the laws of both contracting party and which is punishable under the laws. Both are important. You have to consider the list of offences, but you also have to look at that article for an offence which is punishable under the laws of both contracting parties. So that is clear enough. Response to the chairman's point about certainty, which is very valid. Now, in our requesting letter to the other party, we will only refer to one of the 46 offences in Schedule 1 of the FO order. So the chairman may be concerned that people out there don't know what are the applicable offences. Well, we can do something to assure you, Chairman, because this is after the first time we do it this way. We have a website in the DOJ to set out all the MLAs and FO agreements signed, and then we can list we could include the list of offences exchanged. We can make clear the list of offences included in this agreement. Yes, Mr. Yao. Well, you're referring to the provision of information elsewhere, but I'm still a bit worried. Because according to your schedule, you refer to a list of offences. Please take a look at Annex B, the Chinese. Now, so the list should be a list of offences. You say here that shall exchange the list of offences where the FO order will apply. Unless you have another piece of subsidiary legislation to make that letter part of the subleg. And then that letter will have legal effect. And you say that in future, should there be changes, the other party has to be informed. Then you have to amend the subleg. Otherwise, we don't know what are the applicable offences. I understand that the maximum number is 46. It cannot be 47. But unfortunately, we don't know what are the exact offences, and there is no certainty in the law. That cannot be regarded as the maximum number of offences. There are 46, no more, no less. We're assuming that there are only 23, then there are only 23 and not 46. You know, for instance, the other party doesn't like number 34 on the list. So under the agreement, there should be 46 offences, but because the other party doesn't like offence number 34, so only the order can only apply to 45 of the offences. No. It doesn't operate this way. Whether the other party minds, it will not be a question. We are talking about offences that can apply. Say there is a certain republic. The other party really doesn't like offense number 34. Disregard what it is. For instance, is animal abuse. I don't know whether that's the case. The other party doesn't like to surrender offenders for this kind of offense because it has to promise. They have to promise to surrender fugitive offenders to us for the same offense. So although there are 46 offenses, well, in the agreement, there can only be 45. Now, you won't refuse to conclude the agreement because the other party doesn't like that particular offense because it's better than having nothing. I'm saying that the offenses will not apply to all contracting parties. Yes. Assuming that the competent authority doesn't like this particular offense and assume that we have this exchange of list of offenses, still we will still provide the same number of offenses that are offense on abuse of animal. It will still be included. Then why don't you just write down the 46 offenses instead of saying to provide a list of offenses? Because we don't know whether you will have the same number of offenses in the list. In the past, there have always been the same number, no more, no less. But this time it is uncertain. Mr. Pot-Him. I think for the Czech Republic, they are willing to surrender any offenders that have committed an offense that is punishable by imprisonment of over 6 months. So they don't have any restriction. But for us, we do have some restriction, and that is the 46 offenses. For offenses that are outside the list, we will not entertain such a request. Well, I don't know how many offenses they have, up to 100, a few hundred. Will there be any offenses not covered by our 46 offenses? Is there such a possibility? Thank you. Because under CAF 503, we need double criminality. So it must be an offense punishable both in Hong Kong and in Czech before that order can apply. The chairman said that there might be offenses on our list not acceptable to them. In our agreement, in our negotiations, were they well aware of what's on our list? They have never raised any objection to any of the offenses on the list. And that's why we can come to an agreement. Then why do you use this approach? It's strange. They say that it's okay. Then why don't we go for the usual way? Well, for jurisdictions practicing continental law, this is something new to them, and they need the approval of their parliament. And if such a list appear in their draft legislation, that may be an obstacle to the approval by their parliament. We've come to an agreement because we have an understanding of the offences involved. So you don't want to include the list so that their parliament will not be able to see it? Mr. Yao, I appreciate your concern. Chairman, let me say that there is certainty there. Every time we negotiate with other jurisdictions, MLA or FOA, we have to suit the different circumstances in the legal arrangements or constitution of a particular party. So at the request of the other party, we have to make some amendments. The ultimate goal is to conclude an agreement because such an agreement is useful in the future. Of course, for fundamental principles, we cannot compromise them, but without jeopardizing these principles, we will consider some amendments in format. Mr. To asked whether we can have an alternative approach to achieve the same purpose. Well, in future, when we discuss with jurisdictions practicing in continental law, we can certainly consider this possibility. No. Well, we have vetted similar orders numerous times. Mr. Court-Him was also party. No. It used to be Mr. Lau Kwong-Wah. Adaptation that would not affect the fundamental principles is okay because we have gone through dozens of such orders. But this way is like a carte blanche. No, I'm not so experienced here because I seldom took part in such subcommittees. But I think for surrender of FOs, the most important point is to ensure that offenders would not be surrendered to because offenders might be surrendered to a contracting party with a different legal system from ours. So we have to ensure their interest. My bottom line is, I can ensure that only offenders that have broken our law will be surrendered. They may not be willing to list out all the offences permissible, but I think this is just about the best presentation. So, as we say, there can always be a better approach. We can't find the best approach. But you have to understand the logic behind it. We have signed agreements with other jurisdictions with continental law because a list has to be provided ultimately, unless you say that there will be no list. So for us, the list for us will be 46 offences, and for them, the list will be one description. Is it true that the 46 offences will be handed to them, but for them, they are not going to give us a list? No. It is said in the law here that there should be an exchange of a list of offences. Let me try once again. I agree with Mr. Ip that there may be adaptations to some of the articles. We cannot go beyond the framework of our FOO or SFO. No. Of course, you have to stick to that because that is what's in the law. So, regarding certainty, I must say that we talk about surrender shall be granted for an offence which is permitted by the laws of both contracting parties. But that is a maximum. No, it's not the maximum. We will provide the full list of offences, no more, no less. But you don't know what are the offences from the other party. Well, regardless of the offences from the other party, we have to satisfy the principle of double criminality. You say here they shall provide the other with a list of offences. Why don't you turn that letter into subsidiary legislation? It has to be done, otherwise the order cannot take effect. So for the Czech Republic, instead of enacting only one piece of subsidiary legislation, it has to have two. It doesn't matter, so long as we have certainty.
Mr. Chairman, I follow what you're trying to say, but I want to tell you that certainly is there. When we prepare this piece of subsidiary legislation, you say that offences permitted by the laws of the two jurisdictions, so that does not go beyond the scope of the Fugitive Offender Ordinance and then the certainty that's in Schedule 1. In the agreement, as to what offences are extraditable. That is on the basis of our principal legislation, the Fugitive Offenders Ordinance. So can I ask our legal advisor this? Mr. Yao said that whatever, as we sign an agreement with any country, if the other party asks for 45 offences, not 46, we'll still give them a list of 46 offences. Is that what is said in the law? Do you follow me? So let's say we agree to include a list of just 20 offences. So that's the flexibility. Although the law permits 46 offences, so definitely it's the concept of maximum. How can it be the case that it's all 46 offences? So it's a technical issue. Legal advisor, please. Is it the case that it has to be 1 to 46? It's all or nothing. Is it the case? Otherwise, we don't sign an agreement. Is that what it is? Mr. Chairman, on this point, my understanding, perhaps I could talk about the previous practice and the current practice here. The previous practice is that we will first agree on the principle of double criminality, and then we will include the identical offences on the list, Schedule 5. So for those referring to the law, they will know exactly which offences are extraditable. But in the new approach, the Hong Kong side would only give a list of the 46 offences in Schedule 1 to the other parties. As to how many offences are on the list of the other party, we wouldn't be sure, because this is not part of the legislation. So for people referring to the legislation, or as we refer to the Hong Kong laws, we wouldn't know which are the offences. And so there's no certainty nor transparency to those referring to the law. So it's about certainty and clarity. Mr. Yao, that's the other point. But what Mr. Yao said is that we can give them a list of 46 offences, and then they come back with a list with a certain number of offences. And we can't just say pick 30 offences and negotiate on that basis, because they would just give us 30 offences, not 46. Is it a case in the past that there could be just 30 cases? No. In the past, for most cases, it's 46 offences. But then your question is, it could be 45 offences, right? So that means with the other party, I think what the legal advisor is saying that for the two parties, there must be certainty and clarity, and we can see that in the law. But then they're saying that it's all inclusive, actually, in the list. No, they're saying that there will be an exchange of the list, but then that list cannot be seen in the law. Of course, Mr. Yao said that this could be uploaded to the website of the Department of Justice, but that does not form part of the law, right? But then that does not undermine the certainty of the law. No, how can it be? Because say someone who wants to read the law, who is bound by the law, he couldn't see it in the law. How can that be clear? Honestly, Mr. Yao. I simply find that it's very easy to follow what the legal advice says, that you compare the two lists and you include it in the law. Now it's been done all along. How come we want to change it? Well, that they've explained, Mr. Sin, because the Czech Parliament is not used to the list approach, and if they see a list of 46 offences, they might ask what it is, and that may slow the passage of the agreement. And so perhaps they'll just tell the Parliament we're going to have an exchange of lists. So I asked them, how are you now helping them to deceive? Well, perhaps not deceive, but you're trying to pull wool over the eyes of the Parliament so they wouldn't know exactly what the list is. And then it will be between governments that the list will be exchanged. That is their explanation. That's what they're trying to say. That is the Parliament might be taken aback to see a list of 46 offences. I think they explained it in another meeting or previously. well, the Parliament part I mentioned, but the main reason is because there is not a list in their law. So the Parliament, of course, doesn't understand about the list because it's not in their law. Well, if there is not such a list in their law, then how is it possible that they exchange a list with them? Well, I did mention that we asked for an exchange of lists. We asked for it because it's in our law. But can you not say the contracting parties shall exchange a list of offences? Of course, if it's exchange, it has to involve both parties. It can't be one way. So is it the case that they will give us a list? They're not going to give us a list. There will just be one item. So that's the list is just one item. So in agreement you can include their one item and our 46 offences. Why can't it be done? Unless you're saying that we shouldn't exchange the list altogether. But you say you're going to exchange the list, so it's a matter of whether you include the list in the law. That's all. Mr. Leung? First point. Just now the legal advisor made a point. That's what I believe in too. Because the way it's done now is confusing. You say, yes, there is another article that gives play to double criminality. But and then, as the chairman put it, I think what he said is indeed a problem, because we have 46 offences, the other is just one, maybe less than 46 offences. Then we have to keep looking, and then we'll find, well, only if there's double criminality before the offence is extraditable. So isn't it more confusing, more complicated that way? And then it's not clear. Now, I follow what you're saying, but I think what the legal advisor said was important, is that there is no clarity and it could be confusing. Even for the chairman's suggestion, I think that could be confusing. But then here you also said, under Article 2, before the coming into operation of the agreement, there will be an exchange of lists. And you said there's only one item on the list, so it's not a list, really. No, the Czech said it's just one item, so it's still a list. Otherwise, it's breach of the contract. No, they have a list. The list is just one sentence. Yes, the one sentence is all offences. That's why I say it's confusing. But if you try to word it like the chairman suggested, then we have 46 offences, and then the other says all offences. But I wouldn't know which exactly, and I have to go to Article 3, and then I have to see, only the overlapping offences apply. But then what you say, it could happen in other circumstances. For example, theft. The offence of theft, we might say theft of a mobile phone is one offence, theft of book is another offence. It may attract a heavier penalty. And so it could be not just 46 offences, if that's how they classify offences. So it is a possibility too. Now we're saying that it cannot be just accessible by the legal professionals. Others who read the law should be able to follow what's going on. Otherwise, only lawyers will be able to understand what's going on. It can't be right. Otherwise, people will have to always go to a lawyer. So I'm saying that there has to be clarity in the law so everyone could understand what's going on. So if at the end you still have to exchange a list with them, I think you should exchange the list first before you come back. To me, as a legislator, I would ask, how come you're making things so confusing? So I cannot endorse such confusion. Second point, question was not answered earlier on. The chairman asked it. 46 plus in infinite number. So does it mean that the maximum is still 46? He said yes, but no, I don't think that's clear. So at the end of the day, what is the maximum value? Would it be smaller than 46? Mr. Chairman, I think I follow what Mr. Leung is saying. Yes, every time there is a surrender, fugitive offender, indeed we have to look at the principle of double criminality. It's not just limited to the orders, the agreement signed with the Czech Republic. In the international surrender of fugitive offender mechanism, this is the basic principle, double criminality, that is. And for the 46 offences, they are not exactly offences. We are talking about 46 types of offences, rather. That is in both jurisdictions, whether a particular offence is considered an offence, we'll have to look at the actual act committed before we can conclude whether the act is an offence in that jurisdiction. So the lawyers have to be involved, I'm afraid. But I don't mind that. You talk about types of offences, right? So 46 types of offences rather than 46 offences, right? Well, there are two ways to word it. Let me clarify this point, because you may be misleading colleagues. For some offences, they might say criminal intimidation, so it's intimidation as an offence. But then for, say, number 4, it says here, offences of sexual nature.
Including rape.
So offences of sexual in nature, including rape, or in other cases, homicide is an offence, but criminal intimidation is an offence. But when it comes to sex offences, it just says offences of a sexual nature. Yes, Mr. Chairman, I understand. Because sometimes there may be something in parentheses to say including this and that. So in some cases it could be specific, with 12, for example, offences related to the securities and futures transactions. So that's a type of offence. But in other cases it could be a specific offence. Yes, it's like a sexual offences. For example, buggery in some cases, in some countries is an offence, in others it's not. Yeah, I follow what that means. I'm just talking about whether in terms of types of offences there are 46. That's what I'm asking. Now, if we have 46 types, is the maximum 46 that a common set? Well, of course, whether the two circles overlap completely or not, it depends on the other parties too. Well, but we have to make Mr. Leung understand. So we have 46. The other party is all offences of that country. And you're right to point out that those all offences may not overlap completely with our 46 offences. All their set is bigger than our set. Well, infinity, for them maybe it's an offence for them, but not for us. So let's say we have 46 types of offences. So let's look at it this way. Maybe for 1 or 2 type of offences, these are not offences in their countries, then the common sense is just 44. Yes, exactly. That's the question I asked. Mr. Yao, is that the case? Can I continue, please, Mr. Chairman? Yes, if I may respond to the legal advisor, and the point of clarity is raised by some members. Now, under the current arrangement, even if we're to exchange a list in future, and whether the list is put on the website or provided to LegCo, and it may say that for all offences in the Czech Republic will be extraditable offences, but we wouldn't know what those offences are. But if they refer to the offences in Hong Kong, that will be clear. The 46 is listed out. And the other party, we don't know which are the extraditable offences for the Czech Republic. Yes, we understand it, but this lack of clarity is because of the legal system in the Czech Republic. That's the request they put forward in the negotiations, and as we decide whether we would reach an agreement with the Czech Republic, we have to take this into consideration. Of course, if there's an agreement, it will help our collective effort in combating crime across the border. But without the agreement, maybe it's more difficult, so we have to take all this into account. And then in 2005, we actually consulted the panel on security, because we take this issue most seriously. But unfortunately, that is the system of the Czech Republic. Now, when we consider whether there's a case for surrender, it will depend on the lawyers of the two parties, and then we'll have to look at the offences of the two countries, especially the particular act, whether it's a breach of the law of that country.
But the law is not just to be used by prosecutors. No, I'm just saying that usually the law will be used by such people. Mr. Ip. Yes, our 46 offences is clear. Chairman, you asked whether that can be in the form of a subsidiary of an order. Well, all 46 offences are open, clear to the public. We know. I think what is unsure is the Czech Republic. They're not going to give us a list, and they will not agree to our 46 offences. No. But do you understand that there must be an exchange of a list? They're not going to give us each and every offences. Yes. They say that they will only have one sentence. So you just include that into the list. Into the law. Do you get that? It's as simple as that. So you want their list, and that is any criminal offences with a penalty above 6 months of imprisonment. Still, that would not satisfy Mr. Leung Yiu-chung's requirement. Now, I have no objection to this. Well, if it is an offence punishable by over 6 months imprisonment, that is okay. Well, if we add that to the agreement, what is the other party's view? Have you ever considered this? Because you're required to exchange the lists of offences. The agreement has been signed by both governments. So at this stage, there can be no change to the agreement. Ms. Lau? Mr. Ip referred to the request of the Czech Republic, but you look at Article 3. Well, they've already included everything in accordance with their law. For us, well, we have a list. We have a list of offences already in our law. It is nothing new. Although we've mentioned that there should be an exchange of lists of offences, this is a formal channel for both parties to understand the offences involved. So how is it written? How is it written? It's just like 3.3. 3.3, Article 3, subsection 3. Or how is it written? Where surrender is requested for the purpose of carrying out sentence, a further requirement shall be that in the case of a period of imprisonment or detention at least 6 months remain to be served. Well, 6 months. Well, for Hong Kong, it's 12 months, 1 year. Our relevant offence. No. 3.3 is not really an offence. It's just a sentence. Well, offences. Because under Cap 503, our FO ordinance, for applicable offences. Well, please. Here it says that it is an offence that the outstanding imprisonment period is no less than 6 months. It's not about the maximum penalty. Oh, sorry, I got it wrong. Can you tell, Mr. Ip, assuming that Schedule B or Annex B is passed, so you must exchange a list. For us, we know what will be our list. What do you expect them to give you? They will say all offences where the that is punishable by over 1 year's imprisonment. So the penalty threshold is no less than 12 months. Yes. So why can't this be included in the law? If you look at 3.3, Article 3.1, that is our requirement. No. You talk about the offence. Well, Under Annex B, you are going to exchange a list of offences. So you should put it there instead of having subsection 2. Well, on Hong Kong side at least, we have 2 requirements, imprisonment or more than 1 year or more, and also Schedule 1 under of Cap 503. And for the Czech Republic, the penalty should be over 1 year of imprisonment. But, well, take the states as an example, or we have a list, okay? Because they have also got a list. But for the Czech Republic, they do not have a list of offences. Then they can go for a descriptive approach. But they don't need it. They don't need it. But we can put it in our law so that at least we know what are the types of defences. But this description is already found in our law. Legal advisor, do you understand their position? I have been scrutinizing this for so long, I still don't understand. Do you? Can you please allow the other party to supplement? Ms. Lau. So all our agreements are based on Cap 503, which has set out all the circumstances where a fugitive can be surrendered and the relevant offences. This is in Section 2. The interpretation clause of Cap 502, subsection 2. And these are the circumstances in Hong Kong under which a surrender can be done. Imprisonment for at least more than 12 months and also double criminality. Can I take a look at the Czech order? Article 3, subsection 1 of the Czech Republic order. Yes? Please allow me to explain. Article 3.1. It is rather clear. Surrender shall be granted for an offence A, which is punishable. The speaker is not coming through. We do have it tabled. LN 166 of 2013. Hang on. Mr. Yao, please go on. Yes. I'd like to draw members' attention to Article 3, subsection 1. Article 3, subsection 1, I think is rather clear. It's about applicable offences. 1. Surrender shall be granted for an offence A, which is punishable under the laws of both contracting parties by imprisonment or other form of detention for more than 1 year or more severe penalty, and B, for which surrender is permitted by the laws of both contracting parties. So, lawyers need only to consider or read the laws of both parties and will understand whether it is a relevant offence. Of course, we still require the Czech Republic to give us a list of offences. Hong Kong will provide a list of offences to the Czech Republic because this is our legal requirement, and is explained by our lawyer. The other party cannot offer a similar list, but if a lawyer reads the laws of the Czech Republic, it is also very clear. Of course, the way of presentation is different, but the content is just the same. If a member would like to see the lists exchanged, that's perfectly okay. We're willing to make public the documents of exchange. Mr. To asked whether we have other way of presentation to achieve the same purpose. Well, when we negotiate similar agreements with other jurisdictions in the future, that can certainly be considered. But in our negotiations with the Czech Republic, they did so insist, and we've considered that there is no negative impact on our own mechanism, and we also consulted the then security panel, and we finally concluded the agreement in the manner requested by the Czech Republic. Beg your pardon, I'm rather confused. Do they have other modifications? No? No other adaptation? Legal advisor, please. Chairman, you referred to other modifications. I've written to the administration. Under Section 3 of the FO Ordinance, and the terminology there, I asked how come the approach is different. Because the FO order said that by virtue of the order, the arrangements can be included. Which section? 3(1)(a) and B. And secondly, the order also said specifying the extent, if any, to which any relevant enactment specified in the order is to be repealed or amended. So it would be much easier for us. But is anything repealed or amended in the original enactment? Well, the applicable articles are all included in the order. Here, direct that the procedures in the ordinance shall apply as between Hong Kong and the places of Hong Kong to which the arrangements relate, subject to the limitations, restrictions, exceptions, and qualifications, blah, blah, blah. But all the applicable articles are included, but there is no mention of limitations or restrictions. So every time we read the order, we have to compare it with the model text. This is different from the MLA approach, where modifications are clearly spelled out. So this is just a general comment, not restricted to the Czech Republic order. All right, can you respond to my general question? Of course, when we enact a subsidiary association, we'll follow the principal ordinance. I noted that there is a difference in the presentation of the FO ordinance and the MOA ordinance, because the two ordinances were enacted in 1997 at around the same time, and it's true that at the committee stage, the committee required that special modifications be specified in the MLA ordinance. That's the demand of the legislature back then. For the FO ordinance or order, it is still clear because the whole text is repeated. And I understand that for the MO ordinance, there is an extra requirement. Amendments or modifications have to be spelled out. Anyway, it's all because of the requirements of the then legislature.
So you're saying that historically, this adaptations is not spelled out specifically. That's why you have not done so. That's what you're saying, right? So where, at which point is there an exchange? Because it's not in the order. Is there such a sentence in the Czech order? Well, we were looking at Article 3 of the agreement. Article 3.2 refers to the time frame. Okay, fine. Article 3.2, exchange of list is mentioned here. That is, each contracting party shall provide to the other a list of the offences no later than the date on which it notifies the other contracting party the entry into force of this agreement. Now, usually it means, for us, that means Leisure has passed the agreement, and then we will tell Czech that we've completed our legislative process, and then we will notify the Czech Republic what our list is. And when the Czech Republic has completed its process, it will also notify Hong Kong. Well, let's assume this is passed. And so after some time, there's an exchange of lists. Remember, it's the list. Ms. Liu, don't say there is not a list. You mustn't say so. Because the law here says that there must be an exchange of a list. So you can't say there's not a list. There is a list. But then the list does not form part of the law, so we don't know about it. Or you say, okay, you'll be... you will do it this time because you want to reach an agreement, but let's not do it again in future. Because you have to find out a way to include the list somehow. If I let you pass, let this pass, and then you could just tuck the list away, because there is not a statutory process for the publication of the list. I tell you, if that's the case, Dr. Margaret Ng has asked me to resign. Dr. Margaret Ng is, of course, a lawyer, because from the legal point of view, they take this very seriously. Mr. Dennis Kwok is not a member of this subcommittee, but if you can't provide list, and we don't have a mechanism to know what is on the list, it's not right. But here it is. This mechanism. No, you refer to the order. Bracket 2, each contracting party shall provide the other list. In other words, we provide list to the other party. And it's not part of the law. And when they provide a list, there is also not a statutory mechanism for us to publish the list. Well, but then for the 46 offences, they're already there. Yeah, the 46. This is what we tell people about. But when the other party gives us the list, there is a letter that they sent to us. There is not a statutory process for the letter to be published, because they also have to provide list. But our 46, they are already in the ordinance, so we're giving them the list of 46. Whether we give them 46, you should have spelled it out originally. So you mean you saying that we should attach for 46? No, just look at the other orders we have entered into. The public will be able to see, okay, for this republic, these are the 46 offences. Now, you mean in the past there could be this approach? No, not really. Because the other party may not cover all 46 offences. You mean in the past, attached to the order there's a list? Perhaps the legal advisor to give an example of previous agreements signed and then compare that to this particular order, and then Mr. Yip will know what we're talking about. As you're looking for an example. Now, my concern is that it's not that we are not clear on this side, because we list out all the 46 offences, but for the member, for Hong Kong citizen, he wouldn't know the list of the other party, the Czech Republic. Then they would just make a general statement, and that's what it is about. No, if that's in the Czech list, if that's just one sentence, I think that really distorts the meaning of the list of offences, right? People will find it odd that you went about the negotiations this way. Is it the case that continental law, no, but many other countries could do that? Is it that in continental law there is not a list? No, I don't think the Czech Republic is the first country we concluded an agreement with which practices continental law, so it has nothing to do with continental law, right? Well, some countries with continental law have made this request. The Czech Republic is not the first country, but each country may have its own requests. I think, let me remind Mr. Yao and Ms. Liu. This is already a piece of legislation we consider it, the New Zealand order. The New Zealand order, we've listed out under Article 2, 22 offences. In other words, we permit 46 offences for New Zealand. Only if someone's committed one of the 22 offences would he be extraditable. Because New Zealand has the list of 22 offences, that's why. Yes, so that addresses two issues. First of all, it doesn't have to be 46 offences, do you follow? No, but I was saying what list we're going to offer to the other party. And what are the offences permitted under the law now? That's the list we'll provide to the other party. No, still don't get it. Say for New Zealand, it's 22 offences out of the 46. So if we give the list to Czech, the Czech Republic, you're telling us you give them a list of 46 offences. That's my understanding of what you've been saying, right? But then the public wouldn't know whether it's actually 22 or 46, because New Zealand is just 26. That means in some cases they're not. It's not necessarily 46 offences. No, Mr. Yip, it's not about whether it's clear with New Zealand, but it's about whether the public know what offences are extraditable. Of course, that's the ideal situation, but then the Czech Republic wouldn't accede to that. So that's why we're talking about 46 offences. No, I don't mind that there is a list. I'm just saying that list has to be included in the legislation through a statutory procedure. But you mean statutory process for Hong Kong? But in Hong Kong we already list out the 46 offences. But then we don't. You cannot be included in law that we've given the list of 46 to the other party. You mean you need to include the schedule of the ordinance here? No. Now I think Mr. Yao understands what I'm talking about. Okay, we're going to write them a letter, and let's say you say you're going to include all 46 offences. But when you could include 22, really, we wouldn't know. At the end, what is important is that the final list is in the statute for all to see. That's all I want. Now, in New Zealand, if 22 offences that already involves an amendment of the ordinance, but if there is no amendment of the principal ordinance, so of course then all 46 offences will apply. Because in New Zealand, for the New Zealand order, there's already a case. Ms. Liu, of course, it doesn't work. Use your head. Now, we're talking about adaptation to 3.1. You're saying that 46 offences have been adapted to 22 offences, right? That's because the 22 offences have been adapted to 46. No, it's the other way around. 46 adapted to 22. Yes, it's through the New Zealand order that we have adapted it from 46 offences to 22 offences, right? But here it says, shall provide a list. But do we know whether there's any adaptation? If at the end in the letter there's it's 46 offences, that means there's no adaptation. But if in the letter you say 22 offences, that means it's become from 46 to 22 offences. It so happens that now you say with Czech you will include all 46 offences, but we wouldn't know. That's what the legal advice has been saying all along. But then there's no way to know. No, Mr. Ip. For that letter, if it's part of the subsidiary legislation, then we wouldn't know. Then everybody would know. You see what I'm saying? The letter that's been exchanged, if it's included as part of the subsidiary legislation, if in the letter we say 22 offences, then it will be like this New Zealand order, 22 offences. If it's 46, then it's 46. But it has to form part of the subsidiary legislation before we could say there's an adaptation to Section 3.1b of the ordinance. Mr. Yao, would you consider how the 46 offences could be given interpretation in the legislation. Because having heard Mr. Toh, the concern is whether we know all 46 offences are covered. Because my understanding is that all 46 offences will be covered. That's our maximum. But your understanding doesn't matter, Mr. Ip. Because for many orders, it's the case that it's not all 46 offences. I think we just want to spell things out clearly through a statutory process. That's all it is. I think that's the consensus. You can go back and think about it. There's no need to haggle over that. Yes, there's no point because we all know exactly what we're talking about. Thank you. Now, please continue with the article-by-article comparison. So I'll start from Article 4 then. Surrender of nationals, Article 5, death penalty, Article 6, basis for surrender, this article is all the same as the model text. Article 7, refusal or postponement of surrender. In paragraphs 1A, B, and C, they're the same as the model text, but we have added sex to provide an added protection. Sex, what do you mean by sex? Why are you adding this word sex? Article 7. Article 7, 1B and C. It's about what factors have to be considered in the case of surrender. Originally, we have race, religion, nationality, and political opinions, but in response to the request of the Czech Republic, we've added sex. Okay. So, for discrimination of that nature, the person's prosecution may be affected. So in this case, you won't surrender the fugitive, right? Yes, correct. Still on Article 7, paragraphs 2 and 3, they more or less correspond with the model text. For Article 7, 3B, or D, the two sides have agreed mutually to include certain international conventions. In those cases, we may consider not to surrender the fugitive. 15C, you say the model text not be included. What exactly is that? Article 15C of the model text. I know they're precedents, but I just want to know what that article is about. Now, I found it, so let me go through it. Is that the prosecution is not made in good faith in the interest of justice, the accusation. But that's important for protecting rights. So how come it's not included? What's the reason? As we consider what, as we consider reaching agreements with some countries, we always believe they will act in good faith in responding to requests for surrender of fugitives. At the same time, if we have any doubt, we could always refuse to surrender the fugitive. But where does it say so? I understand sometimes you could refer to an article. What here is accusation against him is not made in good faith in the interests of justice. So, in which article could you then cite this reason to refuse to surrender? I remember your colleagues explained that in the past. I'm sure I have asked this question. It's not impossible that I haven't. because in some orders there is not this article. I just try to, refresh my memory. Anyway, doesn't matter. Still, you have to go back and consider the issue. Please come back later on this point. I'm sure you have an answer, just that all of a sudden it didn't come to mind.
I can assure members that when we conclude an agreement with a certain party, we have faith in their jurisdiction or their judicial system. Yes, of course I get that. But you don't know who is in charge of the government later. Well, the surrender of fugitive offenders is not a compulsory or mandatory a move. At the end of the day, the requester party still has say as to whether the requester is entertained. Of course, I understand, but there must be a basis in the agreement acceptable to both parties. It's not that we can do as we like. This is not the case. Now, if you say that that ground need not be included, okay. If you say that if the request is not made in good faith, you can use another article to tackle the situation. It's okay. So please think about it and give me a reply later. Sorry, legal advisor. I have a question on Article 7. Which part? The Czech Republic order. I've compared with the model text, and that is 15, Article 15. We have a sandwich clause here, so-called sandwich clause here.
咁咧將佢轉咗做嗰個捷克令嘅時候咧，我發覺呢一句頭先我讀出嚟嗰句咧，佢只係喺7B 嗰度。
Now 7B, it is listed in 7B. Are you referring to Article 7B? No. 7 is refusal or postponement of surrender. So there is only 7, 1, 2, 3. 4131. Oh, all right, you're talking about 73B. Okay. 73B. B4131. Page B4131. Yes, please go on. This is a so-called sandwiched mode. Should apply to A, B, C, and D. Now, if it is translated to the order, then it should apply to both A, B, and C, but I only see that in 7.3b and not in 7.3ac. So you have to prove the elements A, B, C, and you also have to consider having regard to all the circumstances, whether it is unjust or oppressive to return him. Well, item 3 are discretionary reasons for refusal. Since it is not a legal requirement, this is here on because they're acceptable to both parties, and these reasons are reasonable. Although you note that there is a sandwich clause in the model text, we have gone for this because it's agreed with the Czech Republic that this way of presentation is more reasonable. But after all, these are discretionary reasons for refusal of a request. 7.3a is okay because it is about an offense which is not sufficiently serious to warrant the surrender. In the model text is that not serious enough plus unjust. If it is frivolous, If it is too trivial, of course, it's not necessary. B is added here, and D, humanitarian grounds. So you don't have to consider whether it is unjust or not. Well, so long there exist valid humanitarian grounds. There exist valid humanitarian grounds. Well, so long it is not really humanitarian, it's okay whether it is unjust or not. I think the current mode of presentation has widened the scope of safeguard for the persons concerned. All right. Article 8, 1(2), consistent with the model text. And for Article 8(3), the Czech Republic have some different terms from us, so there is some adjustment. That is Article 8(2). Article 8(3) the same. Article 9, authentication. And we followed our domestic legislation, so it's a bit different from the model text. We have adapted this a bit to suit our own legal requirements. What do you mean by Article 8(3)? What is meant by no certificate of conviction on the part of the Czech Republic? It is in our model text, but they have a judgment, but don't have a certificate of conviction. All right. So you've added judgment because the Czech Republic do not issue certificate of conviction. The judgment will clearly spell out the penalty and the sentence, so on and so forth. Yes. Article 9. We followed Section 23 of Cap 503 of our local legislation. All right. Article 10, language. This is new for easy administration. Okay, Article 11, just the same as Article 9 of the model text. Article 11(2) is new for the smooth operation of the order. This is about providing additional information for consideration of a request. Article 12, provisional arrest. Provisional arrest. Is in principle same as the model text. The only difference is the number of days required to submit the order. So we have listed the period here. Article 13, concurrent requests, just the same. Representation and cause, also the same. Representation, Article 14, the Czech Republic. Yes, in fact, identical. Representation and cause identical. We have listed out some exceptional expenses. Article 15, arrangements for surrender. Hang on, I've been reminded by the Secretariat that we thought we could complete the scrutiny by 10:30, and I have also got another meeting. So you want us to speed up? No. The Secretary asked me to discuss with members whether we can extend the meeting for 15 minutes, and we also have to fix a date for other meetings to consider the other order. So members, do we agree that we extend the meeting by 15 minutes? It doesn't matter, but I think it's pointless for us to go on today. I know. Because this is negative vetting, I want to complete this. I'm more for extending it for 15 minutes. Okay, let's go on. Article 15, arrangements for surrender. We have just added some provisions for the smooth operation of the order. Article 16, surrender of property, more or less the same as the model text. Article 17, specialty and surrender. In principle, the same as the model text, but we've added some requirement in accordance with our own legislation. What is 15.3? 15. Article 15.3. Article 15.3. Remove the person. Well, as far as the Czech Republic is concerned, perhaps their country is bigger. They may not be able to remove the person within 14 days from the date of communication of the decision. So how is it drafted here? Shall be no less than 14 days. But it can be indefinite. All right. Within the period specified, all right, they know full well that it can be done within 14 days, and they will give you a specific period. Yes.
Article 16. Surrender of property. And Article 17, speciality and resurrender. Article 18, transit. No, it's 17.2. That's to be included for what reasons? This is to reflect our own legal requirements, and we are amending our own model text. Okay, follow. Okay, no resurrender. That's what it is. That means for Article 17.2, we will add it to all new orders then, correct? Yes. Article 18, transit. Here we just follow the model text. And this already been added to many orders. Article 19 also is the same as the model text. Fine. Shall we schedule the next meeting? Clark, please. This is negative vetting, so we have to rush. (28th of November, Thursday). No? What about the week that follows? 5th of December, 8:30. Well, there's no clash with any other meetings, so please, 5th of December, 8:30. Definitely Thursday. We can't finish electrical meeting. No, they know it, because that's meeting with district council at 10 something. No, the 4th of December. No, the 12th of December will be a busy day for council meeting. Yes, we know that. Definitely we can't finish on the 4th of December, but 5th of December we'll only resume the council meeting in the afternoon, because in the morning there's a district council. That's why we could start in an 8:30 meeting. Thank you. Okay, well, we have to extend the scrutiny period then. Thank you very much. Meeting adjourned.